ladies and gentlemen, thank you very much. My name is Michael Sohigian. I am the current president of the Beverly Hills Bar Association, and I thank you all for attending our Zoom webinar, Busted: New Rules for Litigation in the Age of COVID-19. We want to thank in particular our generous sponsor, R. Leonard CSR. Robin Leonard, who is the president of R. Leonard CSR, is one of our panelists, and she will be talking about remote deposition technology. Robin's firm does a full range of deposition services, as you can see by the materials that you have there, this slide here. She's been doing it for a long time, maybe longer than she would want me to tell everybody on a public broadcast like this one, but she knows her stuff, and she is extremely competent. So I look forward to hearing what she has to say about the subject. We also have Jeffrey Kitchaven, who is a graduate of the University of California, Berkeley, which I commend him for. He and I are both old blues, and of Harvard Law School. He has been a full-time mediator since 1996. So that's, what are we talking here, 24 years coming up, all right, Jeff? And before that, he was a scorched earth business litigator, as his materials show. And he will talk to us a little bit about legal ethics and also about his experience with remote mediations using the technology that we'll be describing. And then finally, last but certainly not least, we have Hillary Johns, a trial lawyer who has tried over 100 cases to verdict. She is a member of the Beverly Hills Bar Association's litigation section, and she will talk about, I think, what we all as litigators are experiencing with the various closures and temporary court rules. And I look forward to hearing what she has to say, and I think you will too. Now, you can see these materials, the names and contact information of our panelists are in your materials. And so if you have any questions to direct to a particular panelist and we don't get to them in this program, I encourage you to reach out directly. So without any further ado, let's have our first panelist, please.
I think that's me, and thank you.
I think that is.
And thank
You're
you.
welcome.
For those who do not know, today is Michael's birthday, so we should all wish him a happy birthday. And thank you for the intro. I did submit some written material. You didn't think you were going to get out of that. We have materials that I submitted along with you. There are the slides and some written materials at my office, and I know that Jeff did an excellent job of submitting some sites too. For the written materials that I've submitted, a lot of those are court orders, a lot of those are news releases, so you will see them on the website. There are a couple of good articles there, including one about the statute of limitations and how that it's interpreted in different states and case law for that. And it's not really necessary that you review all that during the presentation, but if you'd like to take a look. And I'm going to spend a lot of time on the judge's interpretations and current and more of the realistic tips of what is going on in the courts. Most of you who care enough, even the fact that you're here tells us that you care enough about your court system. So there are news updates on these slides. You can see them. You can actually have them delivered in state and federal to your inbox. It's not just the news updates. They also have the orders. So for example, they'll have a press release. Let's say, for example, Judge Brazil just issued this order. They usually have a PDF copy. It'll come right to your inbox. I would really recommend that you do it. As most of you know, anybody who does litigation, you don't just go to one court. This is Los Angeles County specific. There are several other judges. For example, Judge Brazil last Friday gave a Zoom presentation about how he sees his courtroom in LA being run. I know that Judge Wong in San Francisco has one coming up. I believe it's next Thursday. And I believe they're also having one in Orange County. I would really recommend that you get their insights. As we know, judges are people too, and they have different views on this. But what I think we can all agree is everybody's doing the best they can in this situation. But we now, as lawyers, and whoever else is there, I'm assuming there are a lot of lawyers online, part of our, I think, responsibility, and I've interviewed a few judges for this, they think it's also the responsibility, not dumping on us, but saying, look, as lawyers, there's a lot that we can do to help this situation and make it better, and start to think about what a new COVID or post-COVID age is going to look like. Because I don't know that it's going to go back to normal. I don't think anybody knows, but we do have these temporary orders in place. Starting with those of you who haven't read it, this is in the written materials. I would recommend that you read it here. This is Governor Newsom's order here. This is Executive Order N3820 that was issued, I believe, on March 27th. I would take particular look at the language here. And the reason I'm recommending that you do is because they've given the judiciary some extensive powers, emergency powers, to take action here. And part of it is to adopt rules for court administration practice and procedures, as long as those rules are not inconsistent with statute. And there's some other things you may have seen. For example, they've suspended jury trials. The federal courts have suspended grand juries. You've all seen that. You've seen situations where they're giving a 30-day extension for to file an opposition. And courts are closed right now. All hearings are being continued. I'm assuming a lot of you are litigators, and some of you are maybe transactional lawyers. It's been my experience so far that courts are behind with good reason. So for example, you may see your case on calendar one day and look the next morning and you have an order from the court continuing the hearing, and that's all that you'll get. So they're mailing these out as best they can. It's also my understanding they're going in order. So when this first hit, for example, you may have already had this experience where you're like, well, my case is still on calendar, great, but a week later they haven't. They're going in order. So I don't know what date they are on yet, but they go each day by day. And I'm assuming the reason they're doing this is for effective administration, which makes sense. So don't assume because something's on the website that it's accurate. I'm not saying the courts are being inaccurate. What I'm saying is there's a lot of material and things to cover here. And I know that they have a skeletal staff. Some of them are working remotely. I have interviewed a few tech people at the courthouses, and they are still all working full-time remotely as they can. Bringing to a couple issues that I think all attorneys need to address going through that. I know that Jeff is going to speak to civility, so I may touch upon that, but that's really because he is the ethics guy here. We're going to defer to him, and I'm excited about his presentation. There are a few issues that we talked about in preparing this presentation. One is, as a practical matter, what are these things going to look like? I know that Robin and I, who so generously sponsored this, and I'm excited about it, we talked about a few simple things. For example, what is a deposition notice going to look like? I know that some people were curious about that. We have a few state sites and things like that, but looking at I know, for example, in our office, the first few weeks, everybody was saying, I don't want to do anything. I don't know what's going on. I'm trying to grapple with this. But people are doing business now and conducting depositions. The better practice here, obviously, is to get a stipulation. I think that anybody, and I know Jeff may speak to that, but we've chatted about it offline. If someone is unreasonably withholding their agreement to do something, for example, make reasonable accommodations, continue a deposition, give extensions, I don't think that the courts are going to be, I can't speak for them. My guess is in this environment, if you're not cooperating and doing things or unreasonably withholding your agreement, they are not going to be very generous to you and ergo your client. So the better practice here, I think, it should be obvious to everyone. You really, I'm not saying you need to bend over backwards and be overly generous or give away your client's rights, but you really need to make accommodations for everybody. And I think from my understanding of the case sites and of the local rules of court is there are case sites that allow for that. For example, there is Code of Civil Procedure 2025.310, California Rules of Court Rule 3.1010. And they do allow for the taking of depositions orally and by video. I think probably at the moment the better practice is you're going to have an attachment or a description. For example, if it's a party, it's not as difficult to do, but you just put it in the pleading and you notify it. I would recommend that you cite to the judicial. They are also in your written materials. A lot of us have seen the Judicial Council rules, the new rules of court that have come out. For example, UDs are being continued, priority for certain cases, things like that. I know a big one for a lot of people is the statute of limitations. I think it is the better practice right now to cite to those rules, including Governor Newsom's order, including these subsequent rules when you put it in your notice. And I think you need to specifically say that. And we did have the question, for example, when you send out a deposition subpoena, I think you can do I think you can put an attachment in your attachment A, so you may satisfy any statutory requirements. Again, the better practice is to get a stipulation here. I don't see anyone who's being reasonable denying that request right now. But what I do see happening, if someone is not reasonable about it, then you're going to have a problem. Robin brought up the point that there are sometimes, what if someone wants to have a deposition out of state? I mean, there are issues with if you're taking a deposition of someone out of state, if you're not, and as to making sure, assuming you're not crossing a line there as to the unauthorized practice of law, I think that you have to assume that your client and advise your client to make reasonable accommodations. Ex parte communications, I know a lot of people are calling the court, that it's been my experience so far that the courts are being very, very helpful. And a lot of them are anyways, but I think in this environment, what I've seen, and I think it's heartening to see, is that a lot of these people are really trying, not just trying, but succeeding and being very accommodating calling. That being said, I know we've touched upon this in our prep for this. There are situations, if you contact a court through a clerk and start asking substantive questions or don't advise opposing counsel, you can get into ethical trouble. I know that Jeff is probably better qualified to speak to that, but I think that any competent litigator or anyone who goes to court needs to be aware of these rules. So and again, I don't know what the line is. I am more conservative in my approach. I always notify opposing counsel in writing, get their agreement. We're going to be contacting them. I'm not saying you can't be friendly, but these people are probably under a lot of stress, particularly when you can't see them. Asking any other questions from that probably isn't a good idea. I know I have heard from ethics attorneys and legal malpractice attorneys, sometimes even just the act of going over and delivering documents to the courtroom can be a problem for you. So I think that you need to really consider that. Dealing with clients in this, I think we've all had to deal with it so far, particularly if you are litigators. I know from my practice, a lot of our clients saying, well, how soon can I get into court? What does this mean? I have a constitutional right to go to court. You need to start thinking about what those delays are going to cost to your client. If there's true emergencies, there are ways to get around this. I know I've seen some articles and read them. We haven't had this experience yet. I have gone into court during COVID-19. I did not enjoy it. And I got to self-quarantine for 2 weeks, even though I didn't get thing. When you go into court, you need to talk to your client about being on their best behavior. And I have interviewed a few judges, looking at it from their perspective. These people are literally putting their lives at risk when they go to work. So your pleadings better be good. That's what I'm saying. If they don't have merit, don't bring it to me. And I think that's going to be the case even afterwards. It's always been the case, but I think even more so now. But I think you need to talk to your clients about what these delays are. I know, for example, a lot of clients are saying, well, look, can we get into mediation? I've seen a lot of other forms of ADR. I know that Robin and I talked about it briefly. A lot of our clients saying, well, this looks like it's going to be a longer situation than I realized. So let's start depositions. I can at least do those. What do you want to do in that respect? Technology, I know that this is an issue, sometimes becomes an issue. I think with Zoom and a lot of other things today, it's not as expensive as it used to be. But I think you also need to think about that, and our clients need to think about it, meaning who's going to pay for all this technology? And this is from my interviewing superior court judges. They've said, look, we're not the most don't have the most advanced technology. That's no secret. So you need to think about when you're going to court, how much this is going to cost, who is going to pay for it, and what can you do to help the courts so they can when they come into court, they're reasonable, they're prepared, and you can run something efficiently. Recently, I have heard stories from other attorneys saying when they go into court, there's hours and hours of delays, particularly in criminal matters and other matters, because the courts just aren't set up for that. So they spend half the morning with everybody 6 feet apart or further trying to set up video conferencing. So if you want to give good services to your clients, you need to have solutions. You need to talk to opposing counsel, and you need to get over to the courtroom and say, look, what can we do? I mean, we were fortunate here. We were able to do a test run beforehand, but not everybody is able to do that. And I think that you really have to, I think you really have to make these things in advance. And again, a lot of this is just thinking ahead. Could you go to the next slide, please? Thank you. United States District Court has been more clear. They're not letting anybody in their courtrooms. The judges are now saying that unless grand juries are suspended, if you go to their website, depending on the court that you are admitted in, you can do this. You can just go on and say, I'd like to have all the news releases. There's a link right there. You go in, you get their news releases. They'll send everything to you. I would take a look at the protective measures. Those are extended to the federal courts to at least June 1st. I know there's been talk about it being longer, things like that. At most of us who have been in federal, and again, there's some written materials there with the notices and the protective measures. There was some more protective measures that came out on Monday. I want to be very clear. Most of us who practice in federal court know they tend to be more formal there, and they're not kidding. I'm not saying they're overreaching because they're not, but I've seen some very aggressive federal court judges who don't want anything going on in their courtroom like that. So I think the same rules are going to apply here about talking to your clients about options, advising them the delays and what this is going to mean to them. And maybe this is a good time to look into ADR. Maybe this is a good time to look into mediation. Or as I know we're dealing with in my practice, and I know a lot of other firms I've spoken with are dealing with, they say, well, let's take the time to work up this case. Do we want to let it lie for a while? Is that better for the client, depending on what your client is really doing? And I'm sure you've all thought of this. You know, some of our clients are really grappling with if they're going to be able to stay in business. Other clients are saying, oh, great, we have more work than we can do. People are, finding ways to work around this. And could you go to the next slide, please? I think everybody's curious to know how the court sees this and what they allow. And this is, there's some comments here. I don't know, it's online, I believe, for Zoom on the website. You can see Judge Brazil's comments of April 10th. I did not attend, but I reviewed it later, and it's my understanding it was reasonably informative. And I know that Judge Wong is going to be next week in San Francisco, and there are several other judges doing this. And as we all know, judges are human, and the way they run their courthouses are to some degree individually. Some of the comments I think that Jeff is going to do, for example, are civility and being professional. I think I did hear some feedback that some people felt that Judge Brazil wasn't really clear on what was going to happen because he doesn't know. I mean, this is a very fluid situation. I think he's doing what he can do, and I'd like to think he is, and everybody is, to have an effective administration of justice throughout the courts, which is no small task. Some of the things I think that he talked about, that they've announced that June 22nd is the tentative date to reopen the courts. Whether or not that's going to happen, I don't know. E-service, there were some comments about that. If you're not doing e-service agreements, I see absolutely no reason not to agree to it. I don't want to get any paper in my office. I asked several people to do it. Some attorneys prefer a written stipulation. Other people prefer to have some safeguards in place, like, for example, CC my paralegal, or you get a receipt. When you receive it within 24 or 48 hours, please note that you have. I don't see any legitimate reason not to agree to those right now, and that's my comments upon top of his. As we all know, discovery, demurs, summary judgment, there's not going to be any emergency hearings on things like that. He left the door open for maybe a minor's compromise type situation, but unless there is a true emergency and not just my client saying, I really have to do this right now and I can't go on without it, that's not going to work. He had given an estimate as to when jury trials will resume again. He was saying maybe August. I don't know if that's going to be the case. And again, this is a fluid situation. If COVID-19 gets worse, we all know that it may be longer than that. With the criminal matters, there are separate issues with that because of the right to speedy trial and things like that. For the pretrial dates, all pretrial dates when your trial is continued are governed by the new trial date. That includes summary judgment cutoff and things like that. Sometimes when you continue a trial, there's that issue of, well, discovery cutoff at you have it, say last September 6th, you had a trial, discovery cutoff 30 days earlier. All deadlines are being continued. So there's not going to be that issue with the continuance. It's based upon the new trial as I understand it. And if your trial has been assigned to after June 22nd, I know a lot of people were asking about that. It's going to be continued along with every other one because they're going day by day. Court call and things like that, as I understand it, One Legal and a lot of other people are asking people, I think it's cleared up a bit, but they're asking people to call within the week before to schedule court call. You know, often what will happen when you get a hearing set, we know you're appearing by court call, however it is, you do it right away to take care of it. One legal is telling it, court call is telling us that we need to call a week ahead of time. They may extend that out to 2. So don't be surprised if you get a delay there, but I think there's good reason for it. And no settlement conferences right now, as you know, not even by remote. When courts reopen, he was open to having settlement conferences conducted remotely. So you may see that in the future. For courtroom attire, business casual, that's what they're talking about. He talked about whether there would be more remote trials, which a lot of people, I think, are asking. He was very open to having bench trials. Jury trials is an open question. And non-jury trials are going to be continued more often when the courts reopen because of the types of cases and priority takes of. And I think he had, as I understand, he had a very strong emphasis on civility. And I think it's, Michael, I was looking are you talking about Michael, are you referring to the holidays?
No, yeah, I am, but actually I was trying to communicate with all the panelists, because all the attendees, because one of the questions is whether under CCP 12 and 12A, the 17th of April through the 12th of May is deemed a holiday to calculate when you're actually due.
That's my understanding.
Well, but James Ryan raised that it's not in the April 14th order from the Superior Court, and I think he's right. Where it appears is in the Chief Justice's order, and it looks like the Chief Justice's order authorizes LASC to declare that the 17th through the 12th are holidays under CCP 12 and 12A. It says, it is ordered that the court is authorized to do the following. And the second bullet point says, declare April 17 to May 12 inclusive holidays for purpose of imputing time under 12 and 12A. But maybe Judge Brazil didn't actually do that, at least didn't do that yet. That's kind of how I read it.
Didn't clarify. No, it's an open question, and I know it's an open question in other courts because they look at the order and then they go, "It's yes, Mr. Reynolds, your trial in LASC will probably most definitely continue." I agree with you, and you're welcome. We had the same issue in Orange County too, where we were counting the days and the judges weren't clear about it. I can't speak for a judge, but it's my understanding if they're referring to it, they probably mean that, but I wouldn't bank on it. So
a lot of people have questions about commencing litigation, right? I mean, the courts are accepting complaints for filing,
right.
Although there are some orders that have to do some concerns about statutes of limitations. But one of the questions that we had from Adam Streltzer was about the sheriff not serving process, and I don't think that really is something that the Superior Court has addressed. I think that's a decision that the LASD has made. All I would say from my own experience is, there's some process, and Adam raises levying officers. There's some process that has to be served by the sheriff, but not everything does.
Right.
So you can find a private server, so to speak.
Yeah, I think that's usually advisable, particularly in this environment. I would agree with Michael on that. To answer your question, yeah, they're now accepting service of filing of motions too and things like that. You can't call and get a date. You just have to file. So is that answering your question?
Yeah. Yep, I think that's good.
I saw a chat question, will my motion for summary judgment deadline be continued if your trial's continued? Yes, it will. That was what I was speaking to. All discovery cut off, all summary judgment. It's my understanding from his comments that is how it's going to be handled. Other questions I think we talked about. There are a few issues here. I think it's important to remember here too is start thinking about what matters can be handled remotely now and what for judges and what matters can be handled after COVID-19. I'm hoping there's an after COVID-19 or if this is going to be a new way of practicing law. And again, I don't think judges have all the answers here either. But I think everybody needs to start thinking about what kind of technology can work if you go, and that there's not a rule that's going to help everybody. There's no one size fits all solution. I know one judge that I interviewed, Judge Brazil, commented that things that are part of everyday life now in the 1900s, were early 1900s, were never even thought of. And so I think we all, as lawyers, if you get to my next slide, and I'd be happy to answer a few questions. I know the other speakers need to speak. I think the feedback I've gotten from the judges I've interviewed is, and lawyers too, is we all have, and we've all been thinking about it, what does the post-COVID-19 legal world look like? What are these going to cost? I mean, I'm sure cost is always something. What are jury makeups going to be? I know that I've conferred with some of my clients and things like that, and opposing counsel saying, given that you almost have an entire group of society now who's opted out over 60 or 65 because of their susceptibility to COVID-19, I seriously doubt those people are going to be willing to come in and sit in a room even after this. Is there going to be more remote litigation? And what good can come out of this? I mean, I think we can all agree, and I'm going to finish up because other people need to speak. I think we can all agree that everybody's sort of pulled together on this, and you see people from all over the world coming in and making a real effort to contribute to what is really an unprecedented, at least in our lifetimes, national, worldwide health crisis.
So Jackie asks a question that sort of dovetails into this electronic service issue. She says, if my office is closed in accordance with Governor Newsom's order, how can we be expected to comply with discovery without access to clients and documents? I guess that's two questions. One, if you don't have access to your clients and documents, some of that should be dealt with by having, either portable media or remote access to your office servers. But it also is, I think, something that you need to address with opposing counsel, and you should expect the kind of reasonable response that Hillary is urging. But also, the very last paragraph of Judge Brazil's April 14th order talks about e-service, and it's phrased in a kind of an odd way. It doesn't say that e-service of all documents is permitted. It says all parties who use e-filing are ordered to accept electronic service, except where personal service is required. So that creates a question for me. Does this order only apply, for example, to documents that are filed in court and not, for example, to discovery demands or discovery responses?
I mean, for all discovery that's happened since the COVID outbreak, we have had, thankfully, not a single opposing party not agree. But I think I haven't asked him, but I would err on the side of being on the more conservative approach. But and I know a lot of offices are either closed or working remotely. So if you serve someone, it's like, you would think there would be a courtesy copy coming. And I think there should be something like that, but I don't know the answer. But I think, for example, my thought would be, for example, a contempt. I don't know. I know that there are a lot of clients who'd be very angry if their attorney agreed to accept a contempt citation. They're like, no, you have to come and get me. We are still doing service. I think if a person is sued, they may, for example, if you're referring to after the complaint's filed, that's one thing, but what if it's before? Or what if it's a post-judgment matter where something else has come into play? So my read on that would be anything that has to be personally served, you have to do it unless there's agreement with counsel otherwise.
Right, and then I think also there's some concern, it appears, whether the Superior Court has authority to order parties to accept electronic service. So you may still be stuck with, 1016, I think, of the Code of Civil Procedure that applies to electronic service. So as you said earlier in your remarks, you need to have an agreement with opposing counsel to facilitate electronic service. All right.
One other point, just the statute of limitations, there are some interpretations, and then that's again at the beginning, and I think everybody else needs to speak now, but there are some issues of what they can order and what is, if you look at the judge's comments, one of the bullet points is what do judges have authority to do even with Governor Newsom's order, and what is really more a legislative function. And I do believe that Judge Brazil made reference to that too. So but I think other people need to speak now.
You bet. Well, these are issues, of course, that are of great concern to the litigants who number 235 on this webinar. So everybody's got a lot of questions. Look, let's move on to our next panelist. That is Robin Leonard, who is the president of our Leonard CSR, and she's going to talk about how to create and preserve a record in the age of COVID-19. Thank you, Robin.
Thank you, Mr. Sohigian, and thank you everyone for joining us today. I wish it were under very different circumstances, but this very meeting is indeed representative of how we can utilize technology to get around the logistical limitations of the current environment. I'm hoping to share with you an effective approach to facilitating depositions when everybody is limited to working from their home offices. There's a lot of material, and I'll be hitting the high points and would be happy to discuss with you in more detail anything in the future. Next slide. First, I'd like to take a look at where we are. Currently, there is an existential conflict for the legal community. We're being asked to socially distance to stay safe. But if civil litigation is to avoid grinding to a halt, the discovery process must continue and evolve. Next. The challenge that results from the conflict, well, in theory, a deposition requires the attendance of several parties. Of course, there is the witness. Next. Along with the questioning attorney, the opposing counsel, the court reporter, very important, often a videographer, and sometimes an interpreter as well. Next. Generally, that just means utilizing and gathering in a conference room in an office. Next, please. But that won't work now in an era of so-called social distancing. Next. Fortunately, we have a number of ways to utilize available technologies to engineer a workaround. Next. You've probably heard of many companies that provide internet-based conference capabilities. Our firm has found that Zoom offers ease of use and some powerful tools that make it ideal for hosting depositions or mediations. These are easy to set up, allow for exchange of exhibits, have good audio quality, and are easily recorded. Next. To successfully participate in a remote deposition, it's worthwhile to plan just a bit and pay attention to a few best practices. To handle the video, you'll need a high bandwidth internet connection. Wired is better than wireless, and a good microphone and webcam. And be sure to test your connection. To make the remote process even easier for you, our firm provides a complimentary video tech that will be available a half an hour before the remote deposition is scheduled to start. All parties will be invited to attend at this time, so the video tech can make sure that each participant can be seen and heard, and they will answer any questions to ensure that your deposition will run smoothly. There are a few ways to tackle exhibits during a virtual deposition. First, you should always scan and email all exhibits to the court reporting firm's office, so they may provide them to the court reporter for the deposition. The exhibits may be sent to the deponent's location in advance of the deposition, as well as the deponent's counsel. But of course, the downside to sending exhibits in advance is that it allows the deponent and his or her counsel the opportunity to review the documents in advance, which could mess up your Perry Mason moment to provide the smoking gun document that will win your case. So to solve this dilemma, Zoom has a screen share feature where you can pull up a document on your own screen and it will display to the deponent and counsel on their laptop or tablet during the deposition. Displaying exhibits electronically allows you, the attorney, to confront a deponent with a document at the time of your choosing. Arrangements can also be made to have one of our video techs display the exhibits for you during the deposition for your convenience, or if you're a little technically challenged. Next, please. Oh, that was about the exhibits. Yes. Okay, next, please. Thank you. Now I'd like to share a short snippet of a Zoom deposition proceeding. This particular clip is an example of a proceeding that includes two attorneys, a court reporter, and of course, the witness. Next, please. We are on the record in the case of Smith versus Jones, case number 12335 of the Superior Court of the State of California. My name is Robin Leonard, Certified Shorthand Reporter, CSR number 3334. Counsel, will you stipulate for the record that we are convening this deposition remotely and you agree that the court reporter can swear in the witness on camera?
So stipulated.
So stipulated.
Thank you. Ma'am, if you would raise your right hand, please. Do you solemnly affirm that that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, I will.
Thank you.
Ma'am, will you please state and spell your name for the record?
Yes, my name is Emily Green. First name is spelled E-M-I-L-Y. Last name G-R-E-E-N.
Thank you, Ms. Green. Have you had an opportunity to speak with your counsel about the deposition today?
Not today, but the other day, yes.
And approximately how long did you meet with your counsel for?
Objection, irrelevant. Don't answer that question.
On relevance grounds?
Yes, how long she and I met is absolutely irrelevant to this deposition.
Okay, well, how much time, Ms. Green, did you spend preparing for the deposition today?
For me,
Yes.
nothing.
No time at all?
No.
Okay.
I'm just here to tell the truth and nothing but the truth. I don't have to memorize anything. That's easy.
Okay, I'm going to bring a document up now on the screen. I'd like to mark this exhibit as Exhibit A, this document. Do you see the document on your screen, Ms. Green?
Yes.
Do you recognize this document?
I'm sorry, can you repeat that?
Madam Court Reporter, please read that back.
Do you recognize this document?
Yes, I do.
Thank you. That's all I have.
Thank you. No further questions.
Next, please. Thank you to the Leonard family, not ready for primetime players, for participating in that video. And thank you all. And I look forward to answering your questions at the conclusion of this webinar. And of course, if you choose to conduct any depositions during this time of shelter in place, our firm is here to assist you. Thank you to the Beverly Hills Bar Association. And additionally, if you'd like to receive our guide to remote depositions by email, please don't hesitate to reach out to me. Thank you so much. And I believe, Mr. Sohigian, there was a question about Zoom.
Yeah, Robin, there are questions about, we hear a lot about the Zoom bombing and security flaws in Zoom. Are you dealing with those? Do you have a way to try to protect against people, against the security flaws and security breaches?
Yes, there are ways when we set up the Zoom deposition, we can put participants in what they call a waiting room, and we have the ability to actually let them join the meeting so we know exactly who's going to be in there. Also, when you set up a Zoom deposition, you can give it a password. Everybody gets a password. So only those people who are going to be in the deposition know what the password is, and nobody else can join in unexpectedly.
All right, thank you very much.
Thank you.
And again, I appreciate what you've offered, and I know from some personal experience that the services of R. Leonard CS are top-notch. All right,
Thank you.
Jeff Kitchaven, are you there? I only see, there he is. Okay, good. All right, Jeff is, as I said, a full-time mediator with a background in complex litigation. So he's sort of the perfect guy to conclude this presentation, and I'm sure that we'll all be very interested in what he has to say.
Thank you so much, and thanks to the Beverly Hills Bar Association for inviting me to participate, and thanks to all of our attendees for listening and watching this program. So again, next please. Let's start by talking about civility. This is a statement from the LA County Bar Association's Professional Responsibility and Ethics Committee. I'm very proud to be a member of that committee. And let me just read to you the third paragraph. While we expect further guidance from the court system will be forthcoming, lawyers must do their best to help mitigate stress and health risk to litigants, counsel, and court personnel. Any sharp practices that increase risk or which seek to take advantage of the current health crisis must be avoided in every instance. And so there's some interesting questions that are arising, particularly with respect to depositions, and whether these kinds of civility guidelines and the health considerations allow depositions to go forward. Courts are now starting to give us some guidance on these questions, and they're not all coming out the same way. So let's take a look at a couple of examples for some authorities that perhaps you can use in your own practices. First, let's take a look at an opinion from the U.S. District Court in the Southern District of Florida, Miami. Next, please, Genna. This case is called CW versus NCL Bahamas. NCL Bahamas is a company in the cruise ship industry. And the next two, it's assigned to Judge Altanaga and Magistrate Judge Jonathan Goodman. Next. So there was a proceeding in that case where the plaintiff wanted to take the deposition of the corporate designee, a 30B6 deposition of the person most knowledgeable. And the corporation, the defendant, resisted that in a paperless order by Magistrate Judge Goodman, and the whole order is included at the tail end of these materials. Judge Goodman wrote, "It's painfully obvious that counsel for both sides failed to keep their comparatively unimportant dispute in perspective. Would the world end if the corporate deposition did not occur next week? Obviously not. Is it reasonable to require defense counsel to prepare the 30B6 witness for a deposition while complying with the social distancing standard of 10 feet? Absolutely not." Now that sentence is really interesting because if taken to its logical extreme, how would it be possible to prepare any witness for a deposition while complying with the social distancing standard, sharing documents, showing documents to clients? So this case, this opinion by Judge Goodman may stand for the proposition that no depositions can take place. I think the fact that it takes place in the cruise ship industry gives it an additional level of analysis and additional grounds for distinction, because Judge Goodman goes on to write, "Is it rational to expect defense counsel to enlist assistance from cruise ship attorneys and other employees, e.g. to track down documents and information, to adequately prepare the corporate representative when the entire cruise ship industry is on lockdown and thousands of employees have been let go? Of course not. And there were some questions in the Q&A. What impact does it have when people cannot access their offices, sometimes cannot access paper files if they cannot access those things online? And all of those may be reasons why not only civility guidelines, but questions of public health may prevent depositions from going forward. Next, please. Now, here's a little different take on things. This is from Maria C. Walsh. She is the special master in the Massachusetts asbestos litigation. This is a letter that she wrote on April 1st, 2020, expecting at least some depositions to go forward. Next. She writes, while quarantine conditions are in effect, the deponent will be connected to the video meeting. The deponent and deponent's counsel must be separated by at least 6 feet. Deponent's counsel must also identify anyone else in the room and include them on video camera. So this is how Special Master Walsh was trying to deal with the issue of a witness being coached by their own lawyer. Make sure that they are all on screen at the same time. Deponent's counsel and anyone else in the room must remain visible on camera to the discovering counsel throughout the deposition. The interesting question here, though, is what if the deponent and the deponent's counsel cannot be separated by 6 feet because they cannot be in the same room at all? What if they live in different cities? What if, for reasons of health, infirmity, age, contagion, quarantine, whatever, it's impossible for the deponent and the deponent's counsel to be in the same room at the same time? That too may be grounds for resisting a deposition going forward during this time, even if there are other times, other circumstances where a deposition might be appropriate. The big question for those who wish to take depositions is, with trial dates vacated, with discovery discovery cutoff dates vacated, at least in Los Angeles County and in many other places, it'll be interesting to see how those wishing to take depositions meet the argument of what's the urgency? Why don't we wait a while? So, certainly there may be some times where for evidence preservation with elderly witnesses or whatever, you may need to take those depositions. It'll be interesting to see how this plays out, because we're talking not only about civility, but also because we're also talking about matters of public health and safety. There are other orders like this from other judges across the country. Some will go one way, some will go the other. It'll be interesting to see how it plays out. These are a couple of authorities which may help you address these issues in your practice. Next, please.
Yeah, Jeff, the Magistrate Walsh letter is particularly interesting, because I know just from talking to other litigators that this concern about conduct of opposing counsel and the deponent when you're not in the same room with them is one that a lot of litigators are worried about. So I'd be interested, where could our attendees find the copy of Special Master Walsh's letter that you've excerpted here in this slide?
You know what, Michael, I will forward that to you and be happy for you to distribute it to the attendees along with the other materials.
All right, thank you, Jeff.
You're welcome. Okay, next slide, please. Now let's talk about Zoom mediations and the pluses and minuses of those. What I think many mediators are experiencing, many lawyers are experiencing, is that mediations which had been on calendar are falling off calendar for the time being. Again, with trial dates vacated, without the financial pressure of having to spend a lot of money on discovery, the urgency of settlement is diminished, not gone entirely, but diminished, at least for the time being. Sooner or later, though, there's going to be a need to settle cases because of business exigencies that clients are facing, whether they're individuals or companies. There are personal exigencies that people are facing, and they need to put matters behind them. Part of it is that new disputes will be arising. We're all spending a lot of time reading about force majeure and business interruption insurance policies, what happens in employment situations when people are furloughed or laid off. There are going to be a lot of new disputes and conflicts arising out of the COVID-19 situation. And sooner or later, the old lawsuits are going to have to be settled. They're not going to be tried right away. Judge Brazil said that in this conference last Friday, he said that he doubts that any civil jury trials will take place in Los Angeles County until late August or early September at the earliest. And even then, there are serious questions about the proximity into which people will be placed. We've all been in jury assembly rooms. We know how congested they are. And just think about what happens during a voir dire when a courtroom is packed full of people. And even when jurors are impaneled and they're seated in the jury box, they're really elbow to elbow with each other. So the court is facing some serious logistical challenges as to how these trials are going to take place. So for the time being, we're going to see mediations done remotely, and Zoom, as Robin stated with respect to depositions, so with mediations, Zoom seems to be the platform of choice. So let's talk about some tips for doing your mediations remotely on Zoom. Next, please. So first, have the right hardware and software. Robin touched on some of these points. Let me elaborate on them a little. In terms of hardware, you're much better off with a laptop computer than you are with a tablet and certainly with a phone. With a phone, the bingo card of participants will look so small and so tiny, it'll be very difficult to see people close up and try to get some of that body language, facial expression, the nonverbal communication that we're all so interested in preserving, even though we're doing the mediations remotely. So if at all possible, use a laptop computer. And the software. Download the Zoom app. You can log in through a browser. It's much better. You can get a free account. You don't have to pay money for it. It takes 2 minutes to do, if that. When people are using the Zoom app, it's much easier for the mediator to communicate with people. The quality of the image and the sound is going to be much better. So please, tip number 1, use the right hardware and the right software. Number 2, please, dress for success. Let's see what another judge in Florida had to say on this. Next slide, please. So this is Judge Dennis Bailey in Broward County, Florida. And this was an open letter that he wrote to the local bar. It was published in one of the Bar Association magazines down there. I hope you get as much of a chuckle out of this as I did. It is remarkable how many lawyers appear inappropriately on camera. We've seen many lawyers in casual shirts and blouses with no concern for ill grooming, in bedrooms with the master bed in the background, etc. One male lawyer appeared shirtless, and one female attorney appeared still in bed under the covers. And putting on a beach cover-up won't cover up your poolside in a bathing suit. So please, if you don't mind, let's treat court hearings as court hearings, whether Zooming or not. I think the basic lesson is that if you want the folks on the other side to take you seriously, you have to look like a serious person. If you mediate with me, I'm old school. I graduated law school in 1980. You're going to get me in a suit and a tie and a pocket square. For other people, being dressed appropriately for business looks a little different, particularly in the entertainment and technology industries and some other industries. More casual styles of dress are still considered serious for business purposes. Whatever that means in your context, being dressed seriously for serious business purpose, please dress that way. You want to be taken seriously, look serious. Next slide, please. Partial attention. The whole issue of partial attention on the internet is fascinating. Psychologists have written a lot about it, sociologists, anthropologists, everybody. We all know that when you're online, the temptation for partial attention is very strong. Of course, when you're in person, the temptation for partial attention is very strong as well. For example, when you're sitting in a conference room, you might look down at your phone for a minute. You might see an alert that comes across on your computer. You might look out the window. You might steal a private glance at somebody else in the conference room at that time. There are all sorts of partial attention issues that go on in face-to-face communication too. When you're on Zoom though, it's all different and it's all magnified because here we are staring at each other. And if somebody looks down at their phone or looks out the window or whatever, it's obvious. And in face-to-face communication, it would be considered rude to stare at someone in an unrelenting way for long periods of time. But in Zoom communication, it seems to be the other way, that looking away seems to be rude. So these are complex questions that are going to be worked out. There are some points, though, that I think we ought to make. Next line, please. So I think that your camera should presumptively be on when you are in a Zoom mediation. If you were sitting around a conference table with everyone, I don't think anybody would consider it appropriate to swivel their chair around and have the back of their chair facing to the table and have the person themselves looking at the back wall of the room. That's kind of an analog to what it means to have your camera off when you're in a Zoom mediation. You want the other side to feel that you're listening and paying attention and being respectful toward them. You want to put people in the mood to make a deal with you. And engaging in conduct which appears disrespectful or dismissive, it appears like you may be multitasking to a greater extent than perhaps one might wish you to be. Sending that image across the internet is not likely to put the folks on the other side of the table in a warm and fuzzy mood toward you. So presumptively, your camera should be on. Now look, during the course of the day, people need to take washroom breaks. You may have to take a call. Your dog or your child or your spouse may walk into the room where you thought you had privacy. So yes, there are times when you will want to turn your camera off. You want to do that? Just say why you're doing it. People are all going to cut each other a little more slack in the current circumstance. Excuse me, I have to speak to someone in the house for a moment. Excuse me, I have to step away for a moment. That's okay. Just let people know you're doing it, and please don't do it too much. Next line, please. The mediation should be your primary activity of the day. Just as when you come to an in-person mediation, there is downtime, and mediators want you to have some other work to do to keep you occupied and busy and engaged, at least there in the room, while the mediator may be down the hall talking to the other side. We do expect when you come to an in-person mediation that the mediation is your primary activity of the day. When you come to a Zoom mediation, please have it be the same way. If there are short phone calls, short conversations that will take you away from the mediation at various points in the day, that's okay. That's expected. Everybody's going to be doing it a little. Please, though, have the mediation be your primary activity of the day. Next, please. I think here the topic of increased direct communication holds a lot of possibilities. And I think we're going to see how this plays out. And here, I think we may have an exception to the cameras presumptively on rule in order to facilitate more direct communication, particularly what we used to call the opening joint session, which has fallen into disuse among many. I think there may be a chance to bring some of it back with Zoom mediations. Part of the concern that many lawyers have had with Zoom, with opening joint sessions, is that clients may be inflamed and antagonized by what the opposing counsel has to say. And yet there may be certain important points that opposing counsel wants to get across to you and your client, unfiltered, unvarnished, in their own words. One possibility to get that kind of direct communication going without the antagonism that it might engender is to allow your clients to turn their video off and have their name card up while opposing counsel is making that presentation. That way, there can be the immediacy and the impact, but without your clients actually having their face visible, we may be wringing out some of the antagonism and some of the emotionality about which lawyers are rightly concerned and which has led many lawyers to avoid joint sessions. So play with this in your mind. Think about how the technology can be used to your advantage. Cameras on, cameras off, some people's cameras on, some people's cameras off, core moments or phases of the mediation. All very important things to keep in mind as we use this new technology and try to make things better. Next slide, please. Understanding Zoom's breakout rooms. Zoom has a feature called breakout rooms, which allows us to have a kind of an analog, have a reasonable facsimile, if you will, of private caucuses. What a breakout room is, it's a private chat room, if you will, in Zoom, where the mediator, as the host of the meeting, can assign some but not all of the participants in the mediation to have private conversations. So, for example, there may be a room called plaintiff side breakout room, where when the plaintiff and his or her lawyer want to have a private communication, they go there. And on the opposite side of the aisle, virtual aisle, there could be a defendant's breakout room where the defendant and his or her lawyer go to have private conversations. Other platforms, such as WebEx and the others, do not have, as I understand it, this breakout room function. This is the reason why mediators, almost to a one, will advocate using Zoom for mediations. The issues of security, which were mentioned before, are legitimate concerns and need to be taken into account. Some of the things Robin mentioned are very important. Using a waiting room so that the host, the mediator or court reporter, can control who comes in and who does not come in. You use passwords to make sure that you're protecting yourself that way against Zoom bombers or interlopers. You also don't use the same 9-digit code for your meeting room every time. Zoom has a feature where the default is you just use your personal room, like your cell phone number, every time. And there's another setting you can use where it's assigned randomly. So by doing that, you can prevent people who might have had access to the meeting room for your last deposition or mediation from crashing this deposition or mediation. And there are other security features as well. You also have to ask yourself, compared to what? You know, emails get hacked all the time. People use emails for confidential communications. Cell phones, people are concerned about the confidentiality of cell phone communications, whether they can be hacked. Data breaches of one type or another are in the news almost every day. So I don't think we will ever be able to guarantee complete security for Zoom, just as I don't think we will ever be able to guarantee complete security for emails or phone calls on cell phones, and yet we use those media of communication as well. Finally, keep in mind that Zoom is now, I think its market cap is about $10 gazillion. They have a tremendous incentive to make sure that all of these security concerns are addressed. I think they will, and I think we ought to be comfortable going forward using Zoom. If people don't want to use Zoom but prefer to use WebEx or even conference calls on phones, most mediators will be willing to accommodate that as well, even though Zoom, because of this breakout room function, and it's very easy for mediators to manipulate people, traffic people in and out of those rooms, make Zoom the preferred platform. So some things to understand about the breakout rooms. Next, please. You really are in private. When a lawyer and his or her client are in their own breakout room, they're the only ones who can hear each other. They're the only ones who can see each other. And most mediators will disable the text function in a Zoom mediation because the risk of people misusing it, it's not that easy to use for most people, at least right now, until they become more comfortable with it. So that's the way to have private communications, and they are private. Next. You can signal the mediator. There's a function where when you're in a chat room, you're a breakout room, chatting privately with your client, you can signal the mediator, hey, we're ready to talk to you. And that's a very handy feature so that mediators don't just pop in and show our faces in your breakout room and interrupt your conversations, which you want to keep private. Next. But the mediator cannot signal you when you're in a breakout room. And this is one thing that I hope Zoom fixes, because we don't have a way of virtually knocking on your door when you're in a breakout room to say, hey, would you guys like to talk to me? I'm done talking to the other side. I'm happy to talk to you now. So, next please. Keep your smartphone handy and make sure that you have everybody's cell phone number. One thing that I recommend for people who are participating in Zoom mediations, at least the lawyers, is to put in your cell phone number in your name block so that you can contact each other in this kind of back channel communication. Mediation thrives on back channel communications. We want to have the Zoom mediation seem to simulate the in-person model as much as possible. There are times when you will want to have private conversations with people without the mediator knowing that you're having those conversations. That's okay. And the way to do that is to be able to send text messages, not ask the mediator to put you into a breakout room. The mediator, as the host, is the only one who can put you into a breakout room. You can't get there yourself. So you may not want the mediator to know about this. So being able to text privately on your smartphone, bring that smartphone with you and have your cell phone number. I'm recommending to people that they put their cell phone number in their name ID, as I just did a minute ago. Next, please. Finally, think about signatures. It's the end of the day, you're at that champagne moment, everybody's ready to sign. You've been sharing a document. Either there are several ways to do it. You can do it on share screen. Some people are concerned about the security of that. So you can take your Word documents and you can email them to each other as you might in a face-to-face mediation. Then you're ready for people to sign. Well, wait a second. Your client's not there with you. You can't just sit next to them or push that document across the table to them. What are you going to do? So give it some advanced thought. Do your clients have printers at home? Some people do, some people don't. If clients do have printers at home, they can just print it, sign it. If they have a scanner, they can scan it and email it back. Even if not, they can take a photograph with their cell phone and email it or text it back to us. And that way, with an appropriate counterparts provision in the settlement document, we can get the signatures. If your clients do not have printers at home, please familiarize yourself with DocuSign, Adobe Sign. There are a lot of signature programs out there. Those of you who are in law firms or insurance companies or other organizations, your IT department's probably already subscribed to one or more of these document signing services. Please familiarize yourself with it before the mediation. Let's have that logistical detail in place so that all of our negotiation and all of our settlement efforts are not for naught. Next, please. I believe that if anybody here has a question, you deserve an answer. That's my email, that's my cell phone number. Usually at the end of one of these programs, we would hang around for a while and have a cup of coffee or whatever with you, depending on the time of day, and answer your questions there. We unfortunately can't do that today. If anybody has questions, I'm more than happy to answer them. Here's my contact information. Next, please. Thank you. It's a great honor to be included in this program. I'm very happy to be part of it. Michael Sohigian, back to you.
Thank you, Jeff. Robin, you know, a question came up in the Q&A about it. The lawyer asked, can Zoom allow us to video the depo in lieu of a rough? And the larger question is, when depositions are videotaped, and particularly by Zoom, right, which provides sort of an instant recording, are you concerned about your auxiliary income streams like roughs and, you know, quick expedited transcripts, that sort of thing, because somebody can use the Zoom recording to satisfy their curiosity about what the deponent said?
Yes, they can. And but as far as like a rough draft, you still need that to get that from the court reporter. Zoom also does not have a feature where you can timestamp the video. So the reporter's the only one who can do that with Zoom as well.
There's also just the benefit of the written word. You know, sometimes people, I mean, we've all had this happen, hear things differently. No, that's how I interpret it, that's how I interpret it. And sometimes just looking at it on paper. How would you put
Okay,
it?
and the other, I'm sorry, Hillary.
No, that's right. Go ahead.
The other question that we had came from one of our attendees, and he suggested, listening to your presentation, Jeff, that these breakout rooms can also be used during depositions for lawyers to confer with their clients during breaks in the deposition. So, you know, like I always tell my deponents, you know, you're free to, you know, use the restroom, get a drink, you know, stretch your legs, whatever, but please not while there's a question pending. I get deponents taking me up on that offer all the time. So Tony is suggesting that the breakout room might be sort of a virtual, you know, conference for attorney or deponent and counsel.
Robin, do people ask for that in depositions? You're muted, Robin.
Many people like when I'm muted. Thank you. Yes, you can have breakout rooms in a deposition as well. And I also wanted to make one other comment. The host of the Zoom meeting, which would be our Leonard CSR, if you did it through us, they are the ones that retain the video.
Oh, okay. So the noticing party doesn't necessarily have access to the video to review testimony, for example, between sessions, or to prepare a summary judgment motion that needs to be filed, you know, in a few days. Right.
So that's why you still need the court reporter to give you the rough draft.
I see. All right. That's good
Michael,
to know.
And the written record, of course.
Also,
the final.
Sure.
For conversations that people want to keep super confidential, they can just pick up their phones and call each other. They could use WhatsApp or FaceTime if they want to see each other, all that on their smartphones. So there are a lot of ways people can communicate with each other if they're concerned about confidentiality, security, those kinds of issues. There are plenty of ways to skin that cat.
Well, sure, and you and I have talked about this, Jeff. That is a benefit for mediations, but a liability for depositions, because it is another way for there to be, you know, contact and coaching potentially between counsel and deponents, right? So there have been a lot of questions about, you know, how do you how do you keep people honest? And that was why I had asked about Special Master Walsh's letter. I would be interested to see how she addressed all those issues. But one way to do it is, you know, to sit down with your opposing counsel or the deponent's counsel and identify potential problems and try and create a code of conduct or a stipulation that solves those problems before they arise. So what do you think, Hillary?
If I may, I haven't taken a deposition in a long time. But what Special Master Walsh indicated, making sure people sit at least 6 feet apart from each other and are visible on camera at all times, you know, it's awfully hard to give somebody a kick under the table if they're sitting 6 feet away from you. So I think there may actually be less coaching of witnesses by their own lawyers in virtual video depositions if the camera requires everybody to be on one camera at the same time, showing that they're 6 feet apart.
Michael, what was your question?
It had to do with these issues of deponent and counsel conduct, and how do you keep your deponent from receiving coaching when the camera is just focused on her, for example, and you can't really see what the opposing counsel or deponent's counsel is doing.
And as I understand it from technology, there are limitations on how broad the camera view is. I mean, I think that Jeff is right. To the extent you can, you need to have a view of some sort of conduct. I mean, the reality is, if they want to coach their client, unless they're doing it blatantly, which I've had happen in cases, they're going to try to do it either way. We've all heard the classic. I mean, to say it doesn't happen just isn't true. The classic is, my client needs to take a break. You know, usually sometimes they'll do it when you're in the middle of a line of questioning. What I try to do is say, look, could we wrap this up, finish this up, and do it that way? I mean, the reality is people are going to find more creative ways to do that. They are. They're going to put a screen. They're going to put a screen in front of them. They're legitimate concerns that you should have about them. You can put stipulations in them. How would you enforce that? I'm not altogether clear. But I think having people, maybe one sitting a little closer next to them or behind them, there are ways to do that where you can feel more, where the person feels supported. You can actually conduct an effective deposition. You can have a stipulation, but there are some real concerns here. I mean, I agree the kick under the table, but again, unless you have a broad view of everybody, it's going to be difficult to do. But I think having a stipulation in place and saying this is the expected conduct, this is we're expecting to do this, and if there's any other thing, there's also if they're receiving information electronically, we have tried other routes, for example, electronic preservation of evidence and things like that, which we discovered through subpoena can get a little more expensive. But I think those are ways. But I think an unnecessarily aggressive or deceitful, frankly, conduct is going to continue. They're just going to find other ways to do it. And I think we're better served by being aware of it now.
Well, Robin, one of the questions that somebody asked had to do with the additional cost of using Zoom, and it occurs to me that Special Master Walsh's letter suggesting that there be separate cameras on deponent and deponent's counsel adds to the cost. Can you just a straight Zoom deposition using the either a separate webcam or the webcam on the deponent's computer? Is that more costly? Are there any additional costs that would be incurred in that as opposed to a regular, in the room depo, Robin?
No.
Okay, but then to have a separate camera, to have it set up, those sorts of things, it does get a little more complicated, a little more costly, don't you think, Jeff?
Well, the question that I was going to ask along those same lines, Michael, is that a deposition taken remotely by Zoom is not the same thing as a videotape deposition for purposes of using that videotape at time of trial. So, Robin, have you yet had circumstances where a videographer has had to come in addition to all these Zoom cameras going on, where a videographer comes in as well and there's a videotape being made in addition to the Zoom recording?
Not yet until they loosen the stay-at-home orders, because I would not expect that the deponent nor the videographer would want to be put into that situation right now.
Yeah, it's a complicated situation. I mean, there's still a lot, I think, of technology that needs to be figured out to make this work ideally for relatively simple depositions like the one of Ms. Leonard by Mr. Leonard. It can work, but we're lawyers. We can think of a ton of problems, and I'm sure that a lot of the people that are watching this are thinking of problems with it as well. Anything else, panelists? I want to thank our panelists, Hillary Johns, Robin Leonard, and Jeff Kitchaven. They are showing you and have been showing you for the last hour and 20 minutes why we chose them to appear here. I'm very grateful to you for participating, and I think our panelists are as well. You really educated us enormously. As I said, attendees, remember that you will be receiving your MCLE certificate by email tomorrow, and that there will be a link to the materials, but the link has been broadcast repeatedly in both the chat and the Q&A during this presentation. This is the third in by now something like the fifth or sixth in a series of legal issues in the age of COVID-19 presentations by the Beverly Hills Bar. We have one coming up on next Tuesday, on elder law, healthcare law, and trusts and estates. It, like this one, is free of charge. And so I encourage you, if you have the interest and the time, to check in with us then. Eventually, I hope that you will see your way clear to joining the Beverly Hills Bar Association if you're not already a member. This is the kind of support and education that we provide to our members on a pretty much daily basis. Thanks again to our panelists, and thanks to all of the attendees. Stay safe, be healthy.
Thank you.
Thank you, Michael, and
Thank
happy
you.
birthday.
Thank you all.